At this time, what we'll do is go ahead and move forward with Chairman Scoggins' bill here today. We don't yet have a quorum, but we won't vote on it until we have a quorum here. So we'll begin with your bill, Chairman Scoggins. You can go ahead and present it.
Okay, thank you, Chairman Administration. This is House Bill 488, which is LC 412931. This is the same exact bill that I introduced last year that passed overwhelmingly out of the House. It went over to the Senate and they changed the effective date on the bill, which brought it back to the House. We ran out of time. COVID caught up with us. We ran out of time on the last day to try to get the bill passed. But this bill is a bill that deals with the Chief Magistrate Court's compensation as far as changing the brackets that they paid on, the population brackets. They had not had a change to that since 2006, I believe it was, other than the COLAs that they normally get. In 2019, the constitutional officers all got this same exact bill, which is just across the board 5% raise over the population brackets. And this bill also adjusts the compensation for probate judges who also serve as magistrate judges and for associate magistrate judges. And this is a bill that we're just trying to make the field a level playing field for the constitutional officers and the magistrate judges. And I would ask for your support on the bill.
Very good. Thank you, Chairman Scoggins. So I was mistaken a moment ago. We do have a quorum right now with our members that are online as well. Any questions for Chairman Scoggins? All right. And I know this came through the Gunner Subcommittee, received a due pass recommendation. I don't see any questions. Anything online? Seeing none. All right, we'll go ahead and I'll go ahead and hear a motion on House Bill 488. This is LC 412931. There's a motion. Is there a second? Motion a second. Any discussion, proposed amendments? Hearing none. All those in favor signify by saying aye. Aye. Any opposed? All right, it's on to rules.
Thank you so much.
Thank you very much. Now that I know we have a quorum, I know you have another committee to go to, so I'm not going to hold you here.
I'll be back after.
Yes, sir. All right, so we will now move on to House Bill 109. Representative Clark is here. Representative, if you want to come on up. All right, please go ahead and present your bill.
All right. Thank you, Mr. Chairman, members of the committee. House Bill 109, LC 412994S. Hold on, is that?
Yeah, yes, that's what I have.
I had a couple of different subs in my folder. So this is the Child Victims Protection Act of 2021. And it came, how do you want me to present the whole thing to the full committee since we've worked on it in the sub? Or?
I think what would be helpful is just to give a summary of the issue and what your bill does, maybe the legislative history, and then see if there are any questions.
All right. So with this bill, this is, we worked on it a lot last session. It got over to the Senate. It met its ending over there because of Corona, the shutdown and how it slowed everything down. So I brought it back this year, exactly how it passed the House, and then we made some changes in the sub. So what's going on with this bill in lines 19, and 20, so we're raising the age, the statute of limitations to 52 years instead of 23 years. We're also a 4-year window from the date of discovery that it happened to you. So if it goes beyond the age of 52, but it's within 4 years of you discovering that this event that happened in your life has led to some damages in your life, you have a window of, we're moving it from 2 years to 4 years. And so let me keep on going. And then down in line 60 is, well, 60 on an old version. It's lines, we're going to start in around line 56 in the substitute we have here. It opens up a 1-year window for a look back going to July 1st, 1973, regarding entities being a public or private organization that knew that it happened in the organizations, but they covered it up. And so the question is, why the 1973 date? Well, that's when Georgia Code was updated to make it clear that these organizations, these entities, were mandatory reporters. And so it goes back to a period of time. If something has happened and the statute of limitations has expired, a 1-year window to open it up and allow for victims to go pursue justice against organizations that knew it happened and worked to cover it up. I think it's important to discuss the different standards of or burden of proof that has to happen. So in the regular statute of limitations, it is a negligent standard. That 4-year window from the date of discovery is a gross negligence standard. And then the 1-year window look back to 1973 for against entities and organizations that work to cover it up. It is the highest standard in civil cases, being clear and convincing standard. So not only is it limited in the time frame, but you have to be able to prove to a clear and convincing standards that this organization knew that it happened and worked to cover it up and not obey the laws of the state of Georgia in when they were a mandatory reporter. So that's the bill. I'll stand for any questions.
Any questions for Chairman Clark? All right, seeing none, I'll hear a motion if there is one. So motion do pass and second. Are there any amendments or discussions? Seeing none, this is LC 41. Okay, this is LC 412994S. All those in favor signify by saying aye.
Aye.
Any opposed? All right, passes unanimous on to rules.
Thank you. Thank you, members of the committee.
Thank you, Chairman Clark. We have, for our sponsors, we have Rules Committee forms in the Judiciary office. If you wouldn't mind filling that out, we can go and get that signed today for you. Yeah, please go ahead. So we'll now move to Representative Leverett's bill, House Bill 443, and you're welcome to stay where you are if you'd like. What's your number?
12.
Okay, go ahead.
Thank you, Mr. Chairman. House Bill 443 proposes to enact the Georgia Structured Settlement Protection Act, which actually amends and updates and strengthens existing provisions of Georgia law in Title 51. This is basically a model act that's been promulgated by the National Association of Insurance legislators. And it is, again, an updated version of one that was adopted in Georgia in 1999 and was subsequently amended in the early 2000s. The focus of this act is, in my view, to protect sort of the unscrupulous people from taking advantage of the disadvantage. This relates to not to the entry into a structured settlement, but the subsequent sale of a structured settlement in order to try to convert some of the future stream of income into present value cash. And so this act, I think the two primary changes are it requires that entities that are in the business of purchasing structured settlements register with the Secretary of State and post a $50,000 bond. And then it also enhances and makes more comprehensive the text of a written disclosure that must be given to the payee, that is the former plaintiff who is now selling either the entire structured settlement payment stream or a portion, some period of time of it. So I think it helps sort of further strengthen the existing law and bring it up to date. It also makes Georgia law consistent with the laws of currently 48 other states and the District of Columbia. We're 49 and New Hampshire is 50. And I believe the act is currently moving through the New Hampshire legislature. So another thing that a number of the folks who do this sort of thing have told me is important is that it requires that you file the action. You have to actually get a court order. That's currently the law already if you're going to sell the structured settlement. But there's not a provision in law that specifies where you do that. And under this act, you would do it in your county of residence of the payee, that is of the former plaintiff. And that's viewed to kind of avoid forum shopping. Without this, otherwise, unscrupulous structured settlement purchasers would bring their clients into Georgia to get them approved if we were viewed to be more friendly. And it just sort of this new provision would discourage forum shopping. So we believe it is a good update to the existing Georgia law and one that will bring us in line with the vast majority of states. As Chairman Fleming is fond of saying, as a lawyer, he's not real good at math, but I think 48 is a majority of 50. So.
Any questions for the sponsor? All right, hearing none, seeing none online, I'll hear a motion. So a motion do pass. Is there a second? Second, all right. Any amendments or discussion? Hearing none, we'll consider LC 412921, House Bill 443 as introduced. All those in favor signify by saying aye.
Aye.
Any opposed? All right, very good. It's on to rules.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you. All right, Chairman Gunner is presenting a bill right now in Judiciary Non-Civil. So what we'll do is I'll go ahead and move into House Bill 333 at this time. And what I can do is just give you an update of what changes we have in the substitute and hear any questions that any committee members might have. So I'm looking at LC 413004S. And just to begin, you all will recall that the first major discussion that we had was in section 3 about the definitions that were provided. And specifically, there were questions about the electioneering communication definition, which was given. That definition is removed from the substitute due to input given that it may not accurately reflect the state of the case law that was out there. And in order to not cause any ambiguity or confusion, that's out of this bill now. Same thing with membership organization. Out of concern, for unintended consequences for the impact or applicability of that definition, it's removed. But you will see that the public officer definition, which was included before, is still there. The of course, loan and personal asset definitions are unchanged, and the staff attorney definition is also there. So the next major change that I will draw your attention to was the discussion that we had about whether there would be a delegation of legislative authority to the commission, and the concern that any check that we might put on that might inadvertently limit the condition's power that it perceives to have already. And so the concern is that if we required legislative authorization to approve rules and regs provided by the commission, that might actually be a step in the wrong direction. So we have now removed that part from this bill, so that there is no change there. There is a requirement included here which would require that we have consistency between along the lines of a 5-year period for maintaining records for the 4-year term of office, a similar statute of limitations where a complaint could be brought within that same 5-year period, and also for personal financial disclosures that it would be 5 years backwards. Representative Evans submitted some very helpful recommendation as to the runoff issue, and that is incorporated into this bill, removing the 2% criteria in order to begin spending for the runoff. So if it appears the candidate has won the first round, won the primary, for example, money could be spent immediately for the runoff. Also, on page 7 of this substitute, this was, I believe, Chairman Burchett's question about should we include for a 6-year office similar records provision that records must be maintained for 7 years. So that's included. That's line 161 to 163. All right, and if you look at 196, line 196, there is an exception for I'm sorry, this is it's 194 to 198. And the operative language here, the addition here is on line 197, unless such nonprofit organization is a social welfare organization. I think the concern there is if you have, and this is apparently IRS language that designates certain groups that would be of a certain political interest or to advocate a certain perspective that would not be limited from the original intent of the statute, which is you can donate you can gift campaign funds to a like-minded political cause if they're not to be used in the campaign. All right, that, to my knowledge, addresses the concerns that were raised by the committee. It also, I'll note, has addressed different input that we've received that would include, I didn't know that an email would be coming to committee members, but I know committee members received an email just before the meeting today. And it just so happens that the issues raised in that email were already addressed in this draft. So there's no issue there. But I'd be happy to answer any questions if there are any about House Bill 333. Representative Evans.
Thank you, Mr. Chairman. I think the bill looks really good. I did have a question over what we just went over. I've just lost it. Oh, in lines 194 to 198. I know one of the purposes of the bill was to try to keep folks from setting up nonprofits and then sending the money over, or sending it to their husband's nonprofit or whatever. Is the social welfare organization, is that described in case law somewhere? Sorry. Just want to make sure we're not making an exception that swallows up what we're trying to do.
So I think the point is well made, and the reason what I'd maybe propose to do is let me ask Mr. Myers if he can step out on this for a moment and get us some follow-up information on that maybe we can provide here while we're going through Chairman Gunner's bill. That will maybe give us an opportunity to address that. Are there any other questions on the bill? All right, so we'll suspend on House Bill 333 while we look into that. We have one other bill on the calendar, which I presented in subcommittee, which I'll be happy to present here today because Chairman Gunter is in Judiciary Non-Civil presenting a different bill right now. House Bill 409 deals with circumstances where a judge may be a defendant in a lawsuit, and generally the Attorney General would represent the judge in those circumstances, but there are occurrences where the Attorney General may decline representation. An example that was given at subcommittee is if the governor is a defendant in the same lawsuit, then the Attorney General would be conflicted out of representation of the judge as well. In those circumstances, representation falls to currently either the judge hires a lawyer to represent him or her, or a pro bono attorney steps up and expresses a willingness to represent the judge. It's really just a gap that we have in existing laws to who would serve in those types of circumstances to represent the judge. So it's based upon that. The House Bill 409 was brought. It would create this Judicial Legal Defense Fund Commission, and it provides for how the commission would be established. As you can see on page 3, these are judges who would be appointed by the executive and by the leaders of the General Assembly, and also from the Council Superior Court judges and the Chief Justice of the Supreme Court. The provides the term with which the members would serve, and it's important to note that the funds for this would be from the governor's emergency funds. This bill has been drafted, it's my understanding, in consultation with the governor's office, and they're fully aware of this language, that there's a belief that this will handle a real need that we have in law currently, so that these judges have representation in these circumstances, and we address, we don't potentially leave our jurists open to having to defend themselves or having to pay out of pocket in circumstances where they're a defendant of a lawsuit for adhering to their responsibilities on the bench. I'd be happy to answer any questions if there are any. Yep. Chairman Fleming.
Thank you, Mr. Chairman. I appreciate you presenting the bill, and I agree with everything you've done here. I'll mention to some of the members of the committee, this began last year when an attorney in Augusta, a friend of mine, David Bell, came to me, and he is president of the bar's Bench and Bar Committee. I don't know if he came to subcommittee and testified or not, but Judge Chastain, Superior Court judge from South Georgia, is the co-chair, is one judge, one bar member. They studied this for a while. Judge Chastain actually gave testimony at an event that we had, and he talked about his situation where he was sued and everybody else was conflicted out, and there was nobody left to defend the judge. Normally the AG does it, but sometimes when the state gets sued, he's conflicted out, and this would create a organizational process whereby you fill that gap on the occasions it occurs. And I think the governor's chief executive council talked about when the new governor first took the job, they were immediately hit with a 3-day deadline for an answer that had to be filed for a judge who this process was not in place to deal with earlier. So that's my background on why this was needed, and it was well thought out, and the committee's obviously done some good work on it, and I fully support it.
Thank you. Thank you, Chairman, for your hard work on this. I know that this has taken a considerable amount of work over the years. Calling Representative Wilson.
Thank you, Mr. Chairman. I don't have any opposition to this bill. I'm just curious. I don't know anything about the governor's emergency fund. What is that?
So as I understand it, the governor has discretion for use. We appropriate certain funds for use for the governor, effectively an emergency basis, and the governor has wide discretion for use of those funds under the circumstances. And what we would be doing here is allowing for the executive to place money into this judicial defense fund, effectively under the circumstances of need as it arises. Do you concur, Chairman Fleming? Okay.
So it would only be funded if a need is present?
I don't think that that's required, but that's certainly the circumstances that we're contemplating here, depending on what the
I see.
nature of the representation is.
Okay, thank you.
Representative Evans?
Thank you, Mr. Chairman. I like the bill. Certainly want to make sure we protect our judges and don't leave them out there hanging without good legal representation. I have one concern about the language in, it starts essentially on lines 91, but the real issue is 95 and 96, where looks like the governor essentially well, I'll back up and say the Judicial Legal Defense Fund Commission, one of their charges starting at line 91 is to maintain a list of attorneys who are in good standing and are willing to offer their help to the judges. But it looks like 95 and 96 essentially gives the governor veto power over anybody on the list. And given the stated example is that the reason the AG can't help sometimes is because the governor is also a defendant. I'm just wondering if we're setting up a weird position where the governor has veto power over who's going to be on the list, considering a unlikely scenario, but that's what we legislate for. The governor doesn't want the judge to have a lawyer and he won't approve anybody to be on the list. So I was just wondering if we might just leave it with the commission, which obviously has appointments from 5 or 6 different elected officials, and the state bar would be helping. Why do we need that check with the governor?
Chairman Fleming?
I think, Mr. Chairman, that's a fair question. And as I remember going through this, number one, we're asking the governor to allow us to spend his money. Obviously, we appropriate it there, but it's in his fund. And if he's going to be spending it out of his fund, he wanted to be sure that the attorneys that were placed in there understood the circumstances and that there were, obviously in any situation, there's never an endless pot. Also, we need the governor to sign this. This was a negotiation with the governor's office. As a practical matter, this is how it works now. Because there is nothing in place to speedily address this, the governor's office steps up and dips into his fund and goes find a lawyer. It's just on an ad hoc basis because, and as David Dove, the governor's current executive counsel, testified, when the governor first took office, they literally, and I don't know if it's 3 days or 2 days, had to go find a lawyer, and the governor was going to pay for him to defend a judge who a time limit was about to run on an answer in a lawsuit. So it is the way it works now. It was a discussion with the governor's office. They were fine and welcomed a process that would address situations early and identify when there was a conflict rather than everybody wondering who handled it. So it's really not a change from how we do it now. And it was an agreement that if we leave that portion of it in place, that the governor would agree with the bill. Does that make sense?
It does. And you think if we took that out, that we'd be
I
back to-
think you would be delving into the area that there was a request that that portion of it, in the sense of how it works, remain how it is, particularly since we were telling the governor to spend, quote unquote, his pot of money on this.
Okay, no, understood. And it may not create a conflict situation. I could just envision a potential.
And I think
problem.
you ask a
Yeah.
very fair question. And I
Yeah.
think when we get down to the situation, we have so many people conflicted out, you're down to, okay, someone's got to make a decision here. And that's
Right.
kind of what this, I'll call it rare instances,
Yeah.
but nonetheless, it does happen from time to time.
Thank you.
Representative Evans, Mr. Myers, who knows these bills so well, just pointed me to line 28 in the bill, where you can see existing code provides the governor's already given that authorization power. And so if we didn't list it again, we'd actually be taking that away
Gotcha.
from the executive. All right, any other questions? I don't see any. I'll hear a motion if there is one. So motion do pass on House Bill 409 LC 412952S. Is there a second? All right, motion is second. Any amendments, discussion? Hearing none. All those in favor signify by saying aye. Any opposed? All right, the bill passes on to Rules Committee. Okay. So we're Okay, so we're back to House Bill 333, and Representative Evans brought to light, I'm looking at line 197. And the additional language was, okay, and the question that was raised, as I understand it, was whether the language, unless such nonprofit organization is a social welfare organization, will actually have a contrary impact to what we intended with the bill. And so I'd be happy to entertain a friendly amendment to strike that language. And would that address your concern, Representative Evans, if that, okay. Any other questions? All right, well, I'll hear a motion on House Bill 333 now. Motion do pass. Is there a second?
Second.
There's a motion, a second. The first Evans amendment is to strike unless such nonprofit organization is a social welfare organization. Is there a second?
Second.
All right, all those in favor of the amendment signify by saying aye.
Aye.
Any opposed? Okay, it's amended. Any other amendments for the bill? Hearing none. All those in favor signify by saying aye. Any opposed? All right, the bill passes on to rules. All right, so just for scheduling purposes, we have the Scoggins Subcommittee, which is set for tomorrow at 1:30. I believe there's 3 bills on the calendar. 3 o'clock tomorrow is the Gunter Subcommittee, and I believe there are 4 or 5 bills on the calendar. So we have a busy day in subcommittee tomorrow. If you can be there, we would really appreciate it. And we will expect to have full committee on Thursday this week. I know we're running up on crossover day at this point, so just for your planning purposes, that's our expectation. Representative Wilson.
Is there a gunner subcommittee meeting this afternoon?
Tomorrow at
Tomorrow?
3 o'clock. Is it mismarked on the
I have it wrong on my calendar.
schedule? Okay. Yeah, Scoggins tomorrow at 1:30, Gunter tomorrow at 3 o'clock. All right, we're adjourned. Thank you.
Hey, have they actually scheduled crossover day yet?
No, they haven't. No, it
So we
hasn't
still
been.
don't know when it is.
But Monday is day 25, as I believe Representative Bruce. So I understand crossover day is 27, so we're getting very close.
Okay, thank you.
Thank you. We're adjourned.